Assalamu alaikum. Bismillah wa salatu wa salamu ala rasulillah. This is attorney Yaser Ali, and today I'm going to talk about one of the questions we get asked the most from Muslim clients, which is it even legal to create a sharia-compliant estate plan in the United States? Now, what's really interesting about this question is that we get inquiries from attorneys around the country all the time who are asking for assistance to draft sharia-compliant estate plans for their Muslim clients. But oftentimes Muslims reach out and say, I'm not sure whether this is legal. And that's usually rooted in a lack of understanding in the US constitutional system and US law. So I wanted to give you a little bit of background to explain why it is legal and you have a constitutionally protected right to create a Sharia compliant estate plan. So first, it's important to understand that one of the bedrock principles of US constitutional law is freedom of religion. It's one of the founding principles of this nation. And the First Amendment to the US Constitution expressly prohibits the government from infringing upon the free exercise of religion. So you have a constitutional right to practice your religion in this land. And among the practices of your religion is to do estate planning consistent with your faith. And why would I say that? There's actually an interesting court case from 2010 which affirms this principle. And in that case, voters in Oklahoma passed a constitutional amendment banning the use of sharia in Oklahoma courts. Whatever that means, it wasn't clear to anyone, but they passed it. So a Muslim plaintiff challenged the law, and I think this was brilliant litigation strategy, where he said that the law would prohibit him and impede his ability to have his will probated in accordance with Sharia and his faith upon death. The U.S. District Court struck down the law as an unconstitutional infringement upon his rights. And it went up on appeal, and the United States Court of Appeals affirmed. So that case sets a precedent for establishing the principle that Muslims can do estate planning in the United States in a manner that is consistent with their faith. And this is also consistent with the principle of estate law, which says that courts will be deferential to the wills and wishes of the testator or the decedent, the person who passed away or the person who drafted a will. So that said, it's important to understand, secondly, that every state is going to have default laws. And this is necessary in order for society to function. So there may be laws about how property is owned during life and during marriage. So on the west coast of the United States, for example, we have community property laws in Arizona, in California, in Texas. And the community property laws assume and presume that all wealth acquired inside of a marriage is presumptively 50-50, regardless of which spouse earns it and regardless of whose name is on the title. And so a lot of people aren't familiar with these rules, but this is the presumption in much of the west coast of the United States. In the East Coast, there are elective share laws in many states, which state that upon the death of one spouse, the other spouse is entitled to a share of the estate. Oftentimes, the share will be greater than what that spouse is entitled to under Sharia. So it's important to understand these presumptions. And then every state is going to have rules about who gets what upon death. So if you don't make a plan, the state will have a plan for you, and it's not going to be consistent with your plan. So that said, in every situation, you are allowed by law, if you meet the legal formalities, to make a plan that is not consistent with the default laws, as long as you meet the legal formalities. So for example, you've probably heard of a prenup. So couples, before they get married, they can opt out of the presumptive community property laws or the elective share rules, as long as they create a document which is legally binding and enforceable and meets all the rules for a valid prenuptial agreement. Same thing happens in a postnuptial agreement, and the same thing happens when drafting a will or a trust. As long as you create a plan that is legally enforceable, meaning it meets all the statutory obligations, and this is where a lot of the self-help, do-it-yourself plans fail. If you create a plan that is legally enforceable, the state will honor your wishes. Right? With very few exceptions, and there are some exceptions for public policy or for the rights of a surviving spouse, which is important to know and understand, especially as a married couple. You need to make sure that both spouses agree. But by and large, the state will defer to your wishes. And there's even a better way when it comes to Sharia-compliant estate planning, which is don't get the state involved at all. And the way that we typically do this is we set up a revocable living trust, and we fund the assets inside of the trust, And then upon death, we have rules in the trust about who gets what, and we stipulate and we get to pick who's going to be in charge of administering that trust, totally outside of the court system. So the court will have nothing to do with our affairs. And this is usually what we recommend for most Muslims in America, is you should probably have a trust. That way you don't even have to go across this question about what state laws apply and what is the court going to determine, or what is, judge so-and-so going to do with my assets after I pass away. So I hope that's helpful background as to why you have the constitutional right to create a Sharia-compliant estate plan. If you have questions, please leave comments. And if you want to reach out, we'd be happy to assist further.